Welcome to Monday the 24th of August here on Facebook Live. For those who don't know me and have joining us for the first time, I'm Bronwyn Pearson from Pinnacle People Solutions, and welcome to our weekly Facebook Live update. So our company, Pinnacle People Solutions, provides human resource services, advice, solutions, support, strategies, you name it, we do it, in terms of HR for regionally based small to medium-sized businesses and not-for-profit organisations. We are here to help you and your business through these challenging COVID-19 times and all of the time. So please ask any questions that you might have as we go along. I'll do my best to answer those live and real time. Outside of this, you can contact myself or my fantastic team anytime via Facebook, email, telephone, website, YouTube, all of the other social media channels. The details will be provided for you in just a moment in the comments. So, okay, so let's get down to our update for the last week. So breaking news, big changes, things for business owners, their staff and managers to be aware of since Monday the 17th of August. So in the past week, probably the biggest ticket item and the one that we've been asked the most about, further to our newsletter being distributed this week. And if you would like to get notification of that when it comes out, just head up onto our website at pinnaclepeoplesolutions.com.au and you can sign up there. In any case, our circular has been devoted to the decision of the High Court regarding paid personal leave. So what does this actually mean? Essentially, the High Court handed down a decision clarifying how paid personal leave is accrued and taken. This was following, this determination overrules an earlier very contentious decision by the full federal court, which had ruled that all employees were entitled to 10 days paid personal leave, being 10 times 24-hour periods of work each year, regardless of their actual working hours, which caused a great deal of consternation amongst the part of employers. So let's have a look at what did they decide, what was their determination as the High Court. So under the High Court's approach, employees are entitled to 10 notional days leave per year. The key difference from the ruling of the full federal court, is that the duration of a day is determined by identifying 1/10 of an employee's ordinary hours over a 2-week period. So this equates to 1/26 of their total ordinary hours over the course of a year. What does this mean? It means part-time employees will have their leave calculated on a pro rata basis, depending on how many hours they work in a fortnight. So the judgment also clarifies that part-time employees cannot access the same or even more hours of personal leave than full-time staff. For shift workers working varied patterns of work across fortnights or months, employers can determine the value of a day by identifying 1/26 of the employee's ordinary hours over the course of a whole year. This enables employers to ignore weekly or monthly variations in rosters and assess the total hours of work as a whole. In application, it's quite a straightforward return to the accrual of leave on an hourly basis. And the taking of leave by drawing down from the employee's pool of accrued paid personal leave on an hourly basis, which is how the vast majority of employers have calculated it before the full federal court decision. So this is a very good example of a very contentious decision being sensibly overturned. So what does this mean? Let's give a couple of examples. So for full-time staff who's, say, working 38 hours a week and 76 hours a fortnight, they would accrue paid personal leave based on an entitlement to a 7.6-hour notional day. Over the course of a year, a full-time employee would accrue 76 hours of leave or 10 7.6-hour notional days. For part-time employees working 20 hours a week and say 40 hours a fortnight, they would accrue paid personal leave based on an entitlement to a 4-hour notional day as opposed to 7.6 hours. So over the course of a year, a part-time employee would accrue 40 hours of leave or 10 4-hour notional days. We'll give you the link to be able to read the full judgment if that's what you're interested to do. In the meantime, we really encourage you to review these changes carefully to see how they may affect your business and your staff. If you need any further information or specific advice for your business, please don't hesitate to reach out and contact us. We'd be delighted to help you. So that's a fairly major win for and clarification in this past week for employers. The other things that employers need to be aware of this week is in terms of the meeting of the National Cabinet. They haven't unfortunately yet reached consensus on an Australia-wide agreement on how to manage internal borders, despite calls from Qantas and some within the government's own ranks for the need for that. However, the group of state and territory leaders has agreed to come up with a national standard of what constitutes a COVID-19 hotspot, with some states agreeing to make variations to their border closures. So we're just waiting to hear about that. This came about partly as a consequence of some of the questions that were raised about the Queensland government having declared the ACT a hotspot, despite the fact that it's not recorded a COVID-19 case in more than a month. So watch this space. We will keep you up to date on what's happening with borders and clarifications around borders. The next issue that's come up in this past week that I think it's important for us to reflect on is the working from home stats and impacts. So over more than a decade, obviously, a huge number of Australians have made the transition out of the physical workplace and into the home office. But since the COVID-19 shutdowns, we've got almost half of the Australian working population has spent time working from home. And there is starting to form a consensus of experts that at least a significant minority of those newly at home workers will stay there in the longer term. And that has potentially dramatic consequences for the central business districts of Australia's capital cities, but it also has great potential for those people to potentially relocate to regional areas. Many of Australia's largest corporate employers are keeping most of their staff at home for now. That's having a significant impact on small businesses that service CBD and large metropolitan centre staff, office staff in particular. But we're seeing, as a small business that works with regionally based business in terms of recruitment, relocation, workforce planning and so forth, we're seeing a lot of inquiry coming from major capital city centres for people looking to relocate into regional areas, particularly if their employer will let them continue to work from home. Essentially, they can live and work from wherever. So there's a great opportunity building for potential relocation to the regions. Employers are looking at reducing costs. There's become a strong incentive for business operators to keep some, if not all, of their staff working at home, and there's strong incentives for workers to want to stay there. Obviously, for business owners, if they're cutting their need for office space, that's a monumental saving. And on the supply side, there are workers that are looking for more accommodating arrangements. So obviously there's a lot more discourse happening now about bosses wanting to keep an eye on what their employers are doing. And also the fact that workers can suffer mental health and family consequences if the line between home life and work becomes chronically blurred. And if you go back and have a look at our COVID update from last Monday, one of the things that we talked about there was the workers' compensation case that was successful for a woman who was the victim of, or for the family of a woman who was the victim of domestic violence. She passed away while working at home, and that decision was made in favour of her family that it was a workplace death. So go back and have a look at that online update from last Monday the 17th. So this potential impact, by 2019 we had about a third of Australia's working population was working regularly from home, and by the time we got to May this year, nearly half of the Australian workforce, 46%, was mainly working from home. So this is going to have a significant impact. In terms of moving forward to discuss briefly what jobs are currently being reviewed as being vulnerable, We've had surveys come out that show that financial services, consulting and administrative staff are now most worried about losing their jobs, that middle level managers particularly appear to be facing redundancy. And some economists are saying that the removal of a layer of management could boost productivity by encouraging more staff autonomy, which is one of the things that's come about as a consequence of people working away from the office and staff at lower levels having greater autonomy. So what we're starting to see is structural unemployment. So people in those sectors that I mentioned, middle management level roles in particular, and we're essentially seeing the collapsing of layers, particularly within larger organisations that seem to be happening, and white collar jobs in particular. So obviously working from home during the pandemic has opened managers, particularly senior managers, eyes to the potential of or the value of providing lower level staff with greater independence. And so the number of people that it's needed to actually oversee more junior staff is what we're seeing quite significantly change at the moment. And what we're also thinking is possibly going to happen is that we'll get fairly significant cultural change in Australian professional firms, because as they realise that they can actually trust their employees to get work done and they don't need somebody necessarily breathing down their neck. So that will be interesting to watch. We're also interested in keeping a very close watch on changes to the industrial relations landscape at the moment. The union movement have been quite vocal in this past week, making it very clear they're going to push back against the government's industrial relations agenda as concerns start to rise that workers will face cuts to hours without JobKeeper to compensate them. There are growing calls in the government to delay a rise in the superannuation rate, which is due on the 1st of July next year. And that's another sore spot developing in respect of the unions. Sally McManus, who's the Secretary of the ACTU, has set out what some of the threshold issues are for unions that may trigger a backlash. Among them is giving businesses that were once on JobKeeper but no longer the power to drop workers' hours and change their tasks to work without consultation. The second is deferring the legislated superannuation rise to 12%. And the third is adopting employer proposals that reduce workers' rights. So the union are starting to become a lot more vocal around those issues. Sally McManus, Secretary, has declined to comment directly on the progress of the 5 industrial working groups that the Attorney General, Kristen Porter, put in place, which the government are trying to get consensus on for proposals to change industrial relations law and help businesses take on more staff. Those conversations are confidential, which is why she's not commenting on those. The working groups are designed to have a look at enforcing Australia's wage laws, resolving the double dipping issue caused by the federal court decision that gave some casual workers rights to paid leave, letting businesses and their workers strike pay deals more easily, and simplifying industrial law. So they are the 5 things that those working groups are working on, and we'll keep you updated as we hear more about that. On a more community level, there's been some tightened restrictions in New South Wales around community sport for the next 6 weeks. So zone, regional, state or state-based competitions are banned to reduce the mixing of participants and staff between different regions of Sydney as well as regional areas. Award ceremonies, end-of-season social gatherings and post-training group dinners are also banned, and only one parent is permitted to watch team sport where a child requires parental supervision. We've had some changes also to New South Wales school students. So any New South Wales student with symptoms of COVID-19 will not be allowed to return to school until they test negative under the new guidelines. New rules to ensure public schools in New South Wales can continue to remain open during the COVID-19 pandemic have been announced. Students must remain within their relevant class or year group to avoid mixing, while schools must not travel outside their local community or zone. School formals, dances, graduations and social events will not be permitted. Schools will be able to hold a Year 12 assembly without parents to recognise the completion of school. And the new restrictions complement existing health advice for schools and came into effect from last Wednesday, that being the 19th of August. We've seen over the weekend that while businesses and sporting venues across Queensland are set to continue operating as usual for the time being, the Premier has targeted private homes, and on Saturday the state government reimposed a limit of 10 people at private gatherings in homes and in places such as parks across southeast Queensland. Across the rest of the state the limit is 30, but for southeast Queensland that's been reduced to 10 in the home and at outdoor venues such as parks. So in terms of those updates for the last week, what is our advice and suggested actions for our wonderful clients and listeners? First of all, check the calculation of your personal carers leave for your staff. Is it correct relative to the High Court decision? That is something that is really important for you to look at. Of course, any of the things I'm about to suggest that you do are things that we can absolutely help you with, so don't hesitate to reach out. Is the structure of your workplace what you need right now or for the next stage of your business? Is it okay the way it is, or do you need to make changes? If you do, make sure that you do them lawfully and reach out if you would like some advice about that. Are you prepared for the transition away from JobKeeper on the 28th of September or to stage 2 of JobKeeper if you think you're going to be eligible for stage 2? Do you have JobKeeper enabling directions in place at the moment that you will no longer have access to after the 28th of September? Indeed, do you need to put in place JobKeeper enabling directions between now and the 28th of September in order to direct staff to take leave or to vary hours and days of work, for example? Very happy to talk to you about those, but they are questions that you need to ask yourself and make sure that you've got the right things in place. Make sure also that you have robust harassment, bullying and discrimination policy in place. Issues are on the rise and employer accountability is being scrutinised like never before. Just overnight we heard that the AMP chairperson and a key member of the executive team have resigned regarding the handling of a 2018 sexual harassment complaint. So timely reminder for us all to make sure that our policies and procedures are up to date and appropriate. And just as we round off around COVID as well, make sure, if you haven't already, that you've got a COVID safe plan in place. Display your credentials, make sure that your signage and your contact tracing obligations are met. Make sure that you're getting the appropriate records and details of clients and customers. Make sure you have good, robust health and safety policies and consultation in place. While we've spoken today about the increasing trend for working at home and potentially people working and staying working from their place of work, you are responsible for the work health and safety of your staff no matter where they're working for you, including from home and on other premises. Make sure that you've got your staff arrangements in place appropriately in terms of contracts and position descriptions. Keep up that good communication with your team and tune into our webinar this Wednesday at 5:30. So thank you so much for joining us for this Monday's update. We're really delighted to have you with us again. If you've got any specific questions about your business or you would like us to help you out, contact us anytime, obviously by Facebook, of course, but also clearly email, phone, YouTube, website. You can reach us on any of those channels. Now, in terms of our webinar for this Wednesday, because as you know, we do a weekly deep dive webinar into a particular HR topic that perhaps we've been asked about, which is often the case, or indeed that we think it's important for businesses to know about. So this Wednesday, I'll be discussing the potential nasties of employment and how to handle them. And some of those nasties include unfair dismissal, general protections disputes, as well as workers' compensation claims. So tell all your colleagues, your friends and your family who want to know how to ideally avoid those nasties or to handle them if necessary. And they're the nasties that are keeping business owners and their managers up at night. They're the things that wake you up in a sweat at 3 a.m. in the morning. Usually it's money or people, in my experience, for business owners. So let's help you with the people side and save you the dollars in the meantime. So please tune in on Wednesday at 5:30 when I'll be doing a deep dive into the employment nasties and how to avoid them. In the meantime, please hug the people that you can, wave cheerily at those that you yet can't. Stay safe, stay socially distant, wear a mask when you're out in public or in areas where social distancing is difficult. Wash your hands, keep up that great hand and other hygiene, and we'll really look forward to seeing you on Wednesday at 5:30 for our webinar. Take care.